attendees are in listen-only mode.
Hello everyone, and welcome to the webcast. My name is Christine Dursey Davis. I'm the Executive Director of the Ohio chapter of the American Planning Association and Chair of the New Urbanism Division, and I'm your webcast moderator. Today is Friday, June 30th. We'll be hearing the presentation, Images, Creative Commons, and Copyright. For technical help during today's webcast, you can type your questions in the chat box found in the webcast toolbar to the right of your screen, or you can call the 1-800 number shown. For our content questions, it's going to work a little differently this week. We're going to be hearing half of a presentation, then we're going to take questions on that, and then we're going to switch to a different topic and then take questions on that. So for the first portion, you can type your questions in the questions box, again located in the webinar toolbar, and then again you can type your questions in on our second topic once we get that started at the same in the same location. Coming up on your screen is a list of our sponsoring chapters and divisions for 2017. Thanks to all the participating sponsors for making these webcasts possible and free to their members. If you're looking down the list and you don't see your chapter or division listed, please consider reaching out to them and telling them to join us. Today's webcast is sponsored by the Urban Design and Preservation Division, which we'll hear a little bit more about in just a moment. On your screen coming up is a list of our upcoming webcasts. You can register for these by visiting our webcast webpage, ohioplanning.org/planningwebcast. And to log your CM credits for attending today's webcast, just head over to planning.org, log into your MyAPA account, and then you can search for CM activities up at the top, and you can either search by the event number or the title of today's webcast, both of which again can be found on our webcast webpage, ohioplanning.org/planningwebcast. And today's webcast has been approved for 1.5 CM law credits for live viewing only. We do have some recorded webcasts that are available for distance education, and you can check those out again on our webcast webpage. Like us on Facebook, Planning Webcast Series, to receive up-to-date information on our events and our uploads. And we are recording today's webcast. It will be available on our YouTube channel. Just head over to YouTube and search Planning Webcast and it'll pop up. And we'll have a PDF of the presentation available at the conclusion of today's webcast on our webcast webpage. Again, ohioplanning.org/planningwebcast. With that, I'm going to turn it over to Margaret Rifkin of the Urban Design and Preservation Division. Margaret.
Hi there. Yes, this is Margaret. First, I wanted to invite you all to join our division. We have plenty of projects that we'd love to have help with, including our webinar program, which we'd be enthusiastic to have some additional folks join in creating a great webinar program. The next slide shows you what our next webinar will be on, and it's on placemaking and public art with Paula Reese. She's a fabulous compiler and creator of places using art from a variety of sources and working with developers. That is next week. That's July 7th, next Friday, so mark that down. And then after that, Christine will go to the next slide, we have 2 more webinars this year that we're sponsoring. One is on smartphone photography with Elodie Creaney, who's a professional photographer, on September 15th. And I have to say I've taken a course on this, and it's amazing what your smartphone can do. It's absolutely incredible, and she will help us learn even more about that. And then on November 3rd, Path as Place with Cindy Zerger with Tool Design Group. Cindy actually presented Path as Place at the national conference, so you'll be able to get a update and a re-showing of that for your use. So now I'm happy to go to today's speaker, which is the next slide. wherever, there she goes. Images, Copyright, and Creative Commons. Our speaker is Mike Carroll, who's a professor of law and the director of the program on information justice and intellectual property at the American University. He teaches and writes about intellectual property law and cyber law. His research focuses on looking for the balance in intellectual property law over time in the face of challenges posed by new technologies. His research includes projects about the social cost imposed by one-size-fits-all intellectual property rights, which is the whole copyright concept. Professor Carroll is a founding member of Creative Commons Incorporated, which is a global organization that provides free, standardized copyright licenses to enable and to encourage legal sharing of creative and other copyrighted works. He's a graduate of the Georgetown University Law Center and the University of Chicago. And I wanted to mention that one of the courses he offers is Intellectual Property in Cyberspace. So delighted to have him here. Thank you for joining us, Professor Carroll.
Great, thank you. Thanks, everybody, and it's great to be here. Let me go ahead and tee up the presentation. So I am a professor, I am a lawyer, I am not your lawyer. I'm going to talk about copyright law and Creative Commons licenses. I'm going to speak in general terms. During the Q&A, I'm happy for you to ask about, well, how does that apply to X, Y, and Z? I will answer questions in that form, but with the understanding that I'm not giving you legal advice. I'm not applying the law to your particular situation, but to make this a useful presentation to you, the formal sort of prepared presentation is relatively slim, with the understanding that once I get the general ideas and the general principles out, you're likely to want to ask that, well, how does that apply in such and such a situation? And I can answer that, in a specific way to that type of use, but not your use, if you understand that distinction, I hope. So what we're going to do is we're going to talk a little bit about copyright and fair use, which is probably what's directly relevant to most folks' current use of images in planning documents and related uses. And then we'll talk a little bit, we'll do Q&A about those general sort of copyright principles, and then we'll talk about the way Creative Commons licenses interact with those principles and create more freedom to use copyrighted works, including images, above and beyond what fair use permits. So here we go. Copyright is in some ways quite simple, but it's not intuitive to most people. So to follow along and to really understand the world from the copyright law perspective, you have to keep in mind that the main goal of the law is to protect authors, right? To protect authors from people making uses of their work that are economically harmful or otherwise in conflict with the author's desire. So first we have to talk a little bit about what do you mean, who's an author, what does it take to be an author, and then we'll talk about what you get, what copyright gives you as an author, and then I'll talk about as a user of an author's work, what are your rights, because copyright law does have an element of balance in it. It's not all control given to the authors, even though some authors have that view. It's a balance between the two. So for those of you of a certain age, certainly my age, there was a time when you had to opt into the copyright system. If you just published something without putting Circle C on it, you actually gave away your copyright. It went into the public domain. And you used to have to apply and register with the Copyright Office in order to get protection. Those days are long gone. The minute you type out anything on your computer, the minute you write a shopping list, you get a copyright. And that's because ever since 1989, it's been automatic that you get a copyright. You still have to register the copyright if you wanted to file a lawsuit in the U.S., but the protection attaches immediately. And what you get when you get a copyright is a protection over the author's expression, the editorial choices, the creative choices that went into expressing ideas and facts. The underlying facts and ideas are always in the public domain. Anyone can borrow an idea. So, you know, when Hollywood produced 2 different movies based on the idea that an asteroid might smash into the Earth, and those 2 movies were released within, I think it was 8 months of each other, there was no copyright infringement there because they were just using the idea of that catastrophe story, but expressing that idea in quite different terms. Or, for example, in a newspaper article, the journalist gets a copyright or the newspaper gets a copyright in the choice of words, but not in the underlying factual story. In the land use planning context, what that might mean is tables, graphics, or other kinds of representations of data can be copyrighted, but only for the creative choices that went into how those facts or data are being represented. The underlying data can always be reused freely because that's not what copyright covers. As I understand it, our main topic and our main focus is primarily around the use of graphics and images, photographs. And in terms of the sort of minimal creativity test that copyright puts, most images pass that test. The idea is that the photographer makes some decision about camera angle, choice of lighting, and even a paparazzi that happens to throw his hand up and pushes the button tends to get copyright. There is one exception. The courts have said that when museum photographers try to make an exact reproduction of a famous painting or public work of art, and if that work of art has no copyright in it, the photograph also does not have a copyright because the photographer explicitly tried not to be creative about how to represent the image. The whole idea is to be an exact, faithful reproduction of the painting. So there are a few cases where images have no copyright, but for our purposes, we should assume that whoever took the picture is an author and they have copyright. So what does it mean to have copyright? The way the law is set up is sort of, it gives authors a little bit of good news up front, and then it follows with the but. So Congress defined the rights of copyright owners very broadly, and I sort of think about this as the nouns and the verbs. The nouns are what is protected, and the verbs describe what the protection is, and it's basically the exclusive right to do certain things with the copyrighted work. So those verbs are quite expansive and cover all kinds of activities in relation to the copyrighted work. And then Congress set a series of limitations and exceptions that create essentially a set of user rights where the use is permitted even if the copyright owner doesn't like it. So it tells the author up front, you control everything except you don't really. Here are a set of uses that are publicly permitted or are permitted without your permission. So this is the package of exclusive rights. You get to, the owner of the copyright has the exclusive right to make copies. You have the right to prepare derivative works, which means some kind of adaptation. In the case of images, there's a question about whether resizing a photograph is enough to count as a derivative work. If you did a lot of creativity in the way that you might have photoshopped or sort of manipulated a photograph, then that might well count as a derivative work, and would implicate a separate right of the copyright owner. So you might be both making a copy and also preparing a derivative work. To distribute copies is just to, as it sounds. Publicly perform is for moving images. Publicly display is what counts. Any image that you find on the internet is being publicly displayed, and so that exclusive right is also being implicated. So in any kind of internet use of photographs, you are probably reproducing the work, publicly displaying it, and potentially creating a derivative work if some level of photo editing went into that. I've grayed out the last right because it's a very targeted right for the music industry and the record companies, and so we don't have to worry about that, but that's also in the package of rights. So that's what the copyright owner has, and in terms of, you know, I'm hoping that we don't have to be thinking about lawsuits, but just so you understand how copyright protects the author, it gives them the right to file a lawsuit if they object to the use. And what they would have to do when they went into court would be to say, I am the creator of this work, I own the copyright, it's sufficiently original that I have a valid copyright, and somebody went and did what my exclusive rights say, I'm the only one who's allowed to do that. If that happens, then the copyright owner has met their burden, but the case is not over because then the user can say, well, even if I used your work in the way you said, it's permitted because ... and these are the limitations and exceptions that Congress has created. They are, they range. We're going to focus on the main limitation and exception, which is fair use, because that's a general broad limitation that applies across the board. There are other parts of the Copyright Act that read like the tax code. You know, special interests were able to get in there so that playing music at a state fair doesn't require a license because some member of Congress put it in the act that state fairs don't have to pay for the music, just everybody else does. But fair use is probably the limitation and exception that would be most relevant in the land use planning documentation setting, because there is no specific exception for that. And there's a lot of confusion in the public around what fair use is, because parts of the Copyright Act are nice and clean and act like a speed limit, and others are in the it depends category. So what the copyright owner owns is a set of rights that look a lot like a speed limit. Did you make a copy? Yes, no. Were you speeding? Yes, no. On the user side, can I use this without asking for permission? It depends. So what does it depend on? And basically, Congress said there's a set of factors and considerations that help us understand whether we should treat a use as fair or not. I'm going to walk you through the full legal test just so you see it, but then I'm going to try to translate it into an easier to use formulation that really gets at what fair use is about. So here's what Congress said is, the first thing we should consider is the purpose and character of the use. Why is it that the user feels like she or he needs to make this use without getting a license? What is it that they're up to? And there, one question is, should we characterize this use as a commercial use or a non-commercial use, with the idea that non-commercial uses are probably more favored, less likely to be impacting the copyright owner's monetary incentives. And in relatively recent years, well, actually since 1992, the question is this a productive or a transformative use? In other words, are you furthering the general purpose of copyright, which is to promote knowledge sharing, to promote the development of culture, by making this use? Or are you merely substituting, making a use without paying a license because you know, you just don't want to pay? Transformative has a specialized meaning, because you don't necessarily have to transform the copyrighted work to be making a transformative use. If you just copy paste the work, but you do it for a new purpose, for a new context that's outside the sort of mainstream reason that the copyright owner has distributed the work, that may well also be a transformative use. So have you transformed the work, or have you transformed the purpose or context is what it takes. If the court thinks it's a transformative use, then that is a use that is likely to be considered a fair use, because it is likely to be a use that does not interfere with the copyright owner's general economic ability to exploit the copyright. The next two factors are in there. They show up in the cases sometimes. Honestly, they don't really decide the question of fair use in any meaningful way. So the other consideration is the nature of the copyrighted work, and by this we mean, is this mostly like that news article or the data table where most of what's in there is in the public domain because it's facts, and you've got the thin layer of copyright on it because you happen to decide on creative names for your Excel spreadsheet? Or is this a work of fiction or some work that has lots and lots of authorship in it, with the idea that the work with lots and lots of authorship is more likely to be protected, whereas it might be more likely to be a fair use if you had to copy the structure of a data table in order to extract the public domain data. And then how much did you use? And this can be more relevant if we were talking about movies or textual works. With photographs, it's kind of an all or nothing proposition. So it's almost likely to, technically we would count this in the copyright owner's favor because you have to use the whole photo, but this isn't really what's important for the analysis. It's really the first and the fourth factors that the courts are most focused on, which is, why are you doing what you're doing, and are you using the amount that's appropriate for the purpose of your use, and what is the effect of your use on the copyright owner's ability to economically exploit the work. So this is a broader consideration than merely, are you substituting for a sale? If the use that you are making is a use that is customarily licensed, or plausibly we would imagine that the copyright owner would set up a licensing mechanism for you to pay for this use, then that use is likely to be considered not fair, because then it looks like you're simply avoiding a license. But the courts have said that in a world where all I have to say is let's take the example of parody. The courts have said that making fun of a copyrighted work is generally a transformative use that is generally a fair use. If a copyright owner wanted to say, go ahead, you can make fun of my work, but here's my parody license, would you say, well, now it's not a fair use because you're not paying the parody license? The courts have said no. The licensing markets that we consider to be meaningful are basically the ones that are about the economic exploitation of the work. You can't just create a licensing option for all uses and destroy fair use. So transformative uses remain protected even if there is a possibility of licensing. But the licensing opportunities that are protected on the copyright owner side are those mainstream licensing opportunities. And that's going to be tricky for our context, because in terms of image licensing, we think about stock photography and other kinds of licensing markets in images. Those markets cover a lot of different uses. And so the copyright owner would have a decent argument that many uses of images may well be the kind of use for which some people pay a license. And that's what's going to make it a little bit tricky here is in a land use plan, you may well say, I am using this particular image for the purpose of illustrating this particular point, and therefore it's a transformative use. On the other hand, the photographer will say, but I have a licensing market for people who want to use my images in any kind of publication. And what happens in cases like that is it really depends on how tight the connection is between the sort of teaching or illustrative purpose of using the image and the license, and whether that's sort of part of the traditional licensing market. I would say that the one case that is probably most helpful for the argument that using an image in a land use plan for the purpose of illustrating a point or showing what a particular design might look like is actually a case involving the Grateful Dead. So the an author and a publisher did a history of the band, and they licensed a number of the concert photographs from the Grateful Dead, which has turned itself into a very aggressive sort of intellectual property licensing organization. But there was one of the concert photos that they couldn't get a license to. They went ahead and reproduced a version of that image in the book. They were then sued for copyright infringement, and they said, this is a fair use. Our purpose of reproducing this image is to help tell the history of the band, and we need to talk about this concert, and we need to be able to show what the concert photo looked like in order to make our point. And the court agreed that even though 6 out of the 7 images had been licensed, the use of the 7th image as a fair use was a fair use. So looking at our factors, the mere presence of a licensing market does not mean it's not a fair use. It does mean that it requires some thought about the real reason why you're using it and whether it really is needed for this teaching, illustrative, or informational point. So I'm going to stop there for a minute and let the questions come in, because what we're going to talk about in the next section is about Creative Commons licenses as a way to expand the scope of permitted use beyond what fair use permits. So here I just want to address any general questions, and I know some of you may well be copyright owners yourself as photographers or other creative folks and want to know what's in it for you on the creative side, and then any other questions about users. And I did also want to talk just for a minute about sort of what about old stuff? What if I want to use a historic photograph to show what used to be? Copyright lasts for a really long time, but the rules all changed in 1978. So I have to give you an it depends answer. As of right now, anything you create, any photograph you take, the copyright will last for the lifetime of the author plus another 70 years. So copyright basically lasts for at least a century. In the old days, you had to renew the copyright. And so you got 28 years of protection, and then there was an option to renew it and get another 28 years, and then that got expanded. So we'd have to do more digging into the timeline to know whether the copyright was registered in the days when it had to be, and then even if it was registered, was it renewed, for you to know whether the copyright has expired or not on that. So Christine, are there any questions that I should answer?
Yeah, there's a couple. Let's go through a couple of them. In a PowerPoint presentation at a conference, do I have to give credit to any and all images?
Interestingly, copyright does not require credit. It's not formally part of the fair use analysis. The way copyright would look at a situation like that is, are you exercising one of the copyright owner's rights? And the answer is yes, you are making a reproduction and you are making a public display of the image. So then am I allowed to do this without a license? We would go through the fair use analysis that I just mentioned. Why are you using that image? Is it the type of use that normally people pay a license for? It is true that courts will favor users who are willing to give credit. And as a practical matter, so not a legal matter, sometimes that's what the photographer cares about the most. And so I think it's just generally good practice to acknowledge your sources and to give credit where credit is due, but it doesn't formally play into the legal analysis in any explicit way.
Okay, thank you. What is the best way, and I suspect safest way, for planners to use photos of other projects for case studies in published plans?
Well, I think, I mean, we're going to talk about the option to use Creative Commons license material, but the example you're giving is the type of example where I think the fair use analysis favors the use, in the sense that if it's necessary to use images from another plan, and so these are not generic images that you could find anywhere, but you have to use those images to make your point, comparing, for instance, your project to somebody else's project, and you need the image in order to talk about the other project. That's the kind of use that counts as a transformative use. Again, I'm not giving you legal advice, but that, if a case like that were to go to a court would be sympathetic to the need for using that particular image for that particular purpose.
Okay, thank you.
So,
go ahead.
Go ahead. Well, I was just going to say, so we'll get into, for people who are looking for images to just illustrate a general point, your choice is either to rely on your best judgment about whether it's a fair use or not, and whether the photographer is likely to want to make noise about it, or you can go on Flickr or other sources and look for a Creative Commons licensed photograph that would clearly make it, fine for you to make that use. But don't limit yourself to that. There are lots of ways in which the fair use case gets stronger when you have to use a particular image for a particular purpose. Okay, go ahead.
Next one, this is interesting. Are satellite images protected?
It's interesting. There's been some litigation in other countries about that. I like the question. It's a good law school exam question. It goes to this point about creativity. Is there that minimum level of creativity? I think the answer is no. The arguments in favor are that whoever set the parameters. So a satellite photo is a representation of raw sensor data that then gets represented in a particular way. And the argument that is copyrighted is that somebody made some editorial choices about how that data gets represented, in the same way that a photographer makes choices about lighting and setting and composition. The other side is, but it's just being, all of that's an automated process, and it's really just trying to represent the reality of things. So it's more like the museum photograph example. So, I wish I could give you a clear-cut answer, but I think the argument that it's not copyrighted is pretty strong, especially in the U.S., but there are courts in other countries that have been willing to say there is a copyright there.
Okay. So another follow-up. So Google Earth does not own its images?
Right. As far as I know, at this point, they've talked about putting satellites up, but as of right now, that data is coming in from some other source. So that's right. They are not the creators, and I don't believe they're acquiring any exclusive rights.
Okay. Next one, I have a copyright to my book that's published by a firm. Am I limited to having the second edition of the book by another firm?
So that borders on asking for legal advice, but there are, I guess you have to break that down a little bit. So to own a copyright in a book is to own the copyright in your expression, and then authors can sign away their copyright. So a lot would depend on whatever the nature of any publication agreement was, because in some settings, authors transfer their rights to the publisher. So, it would take, it really depends on who owns the copyright and what the terms of the publication agreement would be in a setting like that.
Okay. Site plans are normally copyrighted. Can a municipality copy those plans and give to the public without the owner of the site plan giving permission?
Right. So, I mean, whoever created the site plan in copyright terms is an author, and the author owns those rights. And so the answer would be no, you can't make a reproduction or distribute copies without either a license or an argument that it's a fair use. The fact that you're a governmental entity does not give you protection from copyright. So that by its, the fact that it's for a public purpose and a public use would factor into the first question of the purpose and character of the use. Why are you doing this? But it's not a carte blanche permission to do it. So it would really depend on why you're doing it.
Okay. When it comes to a transformative use, would courts differentiate between a purely public document, like a neighborhood plan that's created for the sole purpose of the public good, versus a document created by a private company with potential profit or private gain?
They might, because in the first case, well, there's a legal issue and a practical issue. If the document was basically created to be shared publicly, we can, in a case like that, you can make an argument that I don't even need fair use because essentially I have what's called an implied license. If the creator, by their conduct, essentially gives you permission, leads you to believe that you have permission, then that's considered an implied license. You're not even at the question of fair use in a case like that. And so it may well be that there's very unlikely to be a dispute just because the use that's being made is the use that was intended or understood to be the use. Whereas in the case of the private company, the fair use analysis would say, well, what was the private company's main objective in creating this copyrighted work, and what are their main means of exploiting the copyright in that work? And is this use transforming? Is it something that's transformative? It may well not be if, in fact, the use is closely related to the purpose, the private company's purpose in creating the site plan in the first place.
Okay. Are proprietary images such as a subdivision sketch the equivalent of copyrighted images? So can images that were used at a public hearing and become exhibits able to be used in presentations by others?
Yeah, that's a great question. There's been a little bit of litigation around that. It's not an automatic permission, but it definitely makes the fair use case stronger, especially if your use is tied to that sort of use of in other words, if the copyright owner put the image into the public record as an exhibit, and then the second user wants to use that as an exhibit from the public record, that's kind of a transformative use, right? Because then you really are sort of using it for the purpose of showing what's in the public record, not for competing with the copyright owner based on why they created it in the first place. But it still is in the it depends category. It's not an automatic.
Okay. Do you have any suggestions for books or publications to reference concerning copyrights?
Ooh, that's a really broad question. I think what I would recommend is what might be more useful. My colleague Peter Yazzie, spelled J-A-S-Z-I, has worked on a series of documents that are called Codes of Best Practices in Fair Use. And what he's done is work with lots of different user communities to take these fair use principles that I've laid out for you and help translate them into common use case situations for lots of different user groups. And you know, possibly the one that they just did for the College Art Association might be the most relevant because it's very focused on the use of images. It's more in, you know, art books and the like, but I think those general principles about use of images might be the best of those. The other one to look at is the best practices for documentary films, where the purpose of the use would seem similar to the purpose of use in this context. And I think those documents are very, you know, user-friendly. They're written in pretty much plain English, or as plain English as we lawyers can manage. And they're very much targeted to the kinds of issues and questions you all have. So although there's not a code of best practice in fair use in land use planning, it doesn't take too many steps of translation away from the other use scenarios to understand what the general parameters are.
Okay. Let's take just one more question and then we'll move on and see where that takes us time-wise. This last question, okay. Is it fair use for a consulting firm to place a TV segment that covered a planning event, like a public meeting, into the consultant's blog or website?
It could be. I mean, again, I'm not, we would ask, you know, why are you doing it? And it's likely that the reason it's being done is to make some kind of comment on the event itself or the coverage of the event. And those are the kinds of uses that generally get treated as transformative use, because you're not directly competing with the TV station for viewers, and you're not making the kind of use that they normally license those clips for. Instead, that's a sort of explanatory use where you need the images in order to make your point. And those tend to be the types of uses where the transformative use argument or characterization is strongest, is I really need this in order to make my point, to communicate what I'm trying to say. Those are the types of uses that tend to be favored as fair use.
Okay, thanks. Do we want to go ahead and move on? And folks, you can start asking more questions based on this next set here.
Yeah, and I think that's right, because we could go on and on all day about fair use. Oh, and I meant to mention on the transformative use point, there was a case against one of the precursors to Google and then Google about image search, because as you might know, Google scrapes the web and makes copies and publicly displays copies of billions of images through the image search. And the court has said that's an example of a transformative use. Although you're copying the entire image and you're not changing the image, the purpose of displaying the image is not to compete with the original photographer. It is instead to provide a search engine for images, and that is a different purpose and a different context than the original context, and therefore it's transformative, and therefore it's a fair use. Okay, so Creative Commons. Creative Commons has been around since 2002, and this is a little bit before social media really exploded and everything. People were blogging, sharing things on the internet without any sort of explicit set of understandings about what permissions were associated with that. And in the absence of any explicit understanding, all you've got is the general copyright rules and the general fair use rules. And in Creative Commons, we thought a lot of what people intended by their sharing was a broader type of sharing than just what fair use permits, but they didn't have any easy way to tell the other people on the internet that that was what their intention was. So we created a set of copyright licenses that essentially allow the owner of the copyright to give additional permission beyond fair use, but still retain some rights and some conditions that protect the copyright owner's interests. We ended up looking at what are the types of uses that people are interested in permitting or encouraging, and how might we articulate those in a way that everyone can kind of understand. And we ended up with sort of 6 different combinations. So you might think about these as basically generalizable terms of use that any copyright owner can attach to their work and say, okay, these are my terms of use. So if we were to talk about one of the licenses, CC BY, the BY means attribution. That particular license says you can do anything you want with my copyrighted work as long as you give me credit. So tying back to what we said earlier, although copyright law itself does not require the giving of credit, you can require giving credit as a term of a license agreement, and lots of license agreements do require that. And because we know a lot of authors care about being recognized and about getting credit, we made it one of the terms and conditions of all of the CC licenses that if you're going to use a CC licensed image, you have to give credit. So what we said is, what is it that people care about? Well, some people care about credit. This idea of share alike is basically, if you use my copyrighted work and you create a new copyrighted work with it, I want you to license your new copyrighted work under these same open terms so that you're not basically taking something out of the commons and just making a new proprietary work. I want you to give back to the commons. So Wikipedia, for example, uses that license. You have to give Wikipedia credit, and if you create a derivative work from Wikipedia content, you have to license your new content under the same license. Some people care about dividing the uses into non-commercial and commercial uses. They're happy to explicitly permit the non-commercial use, but they want to retain the right to enter into a negotiated license around any commercial use. And some users either cannot permit or do not want to permit the creation of derivative works. They're happy for copy-paste, but they don't want you to be creative with their creativity. So we created little icons that sort of basically show you what those 6 combinations are, where BY stands for attribution by the author, SA for share alike, NC for non-commercial, ND for non-derivatives, and you end up getting those sort of 6 packages of use terms. In addition, on the left, we have something called CC0. If you want to completely abandon your copyright, give the copyright back to the public, CC0 is a tool that allows the copyright owner to abandon their copyright, dedicate the work to the public domain. The label on the right is just a way of marking things that are out of copyright. So if you came across Mark Twain's novel, you could put that label on it and say, just to let you know, the copyright has expired in this. You can do anything you want with it. And you end up getting that sort of range of freedoms that you are permitting. I do need to make sure we're clear. These are licenses that attach to a use that is beyond fair use. If what you're doing counts as a fair use, you don't need the license. Even if the license is there, you are not using the license. You're using fair use. These licenses pick up where fair use would otherwise run out. And not all people who use the licenses are as aware of that as I wish they were, because some fair uses are commercial uses. And if you put a Creative Commons license on it and said, well, only non-commercial uses are permitted, that's not actually an accurate statement. It's any non-commercial use that is also not a fair use is what you're licensing. We tried to make this as sort of web-friendly as possible, so we created a machine-readable version of the licenses, and then we created this document, which we call the deed, which is essentially, it is not the license itself, but it's a description of the license that we think a normal reader ought to be able to understand, that basically tells you what you're allowed to do under the license and what the conditions are for using the work under the license. And then up top, we link you to the actual legal document that looks more like this. So we talk about it, the human readable and the lawyer readable versions. But this document you're looking at is the actual license agreement. It's about 4 pages. So for people who want to use images, feel that there may be a problem relying on fair use, then an option is to look for a Creative Commons licensed image. And the biggest database of those is on Flickr, although there are many other sources of CC licensed images. But this is from a while ago. At the time, there were 58 million photographs where the photographer had used the attribution license. So that means even if you're a private contractor, even if you're making money off of the document that you are using the image in, this photographer doesn't care. They just want you to make sure that you give them credit in the use of the document. Other people have a range of other limitations on that. So we could, if I were to, so here's on the live web, that number's now up to 76 million under the attribution license. And you can see that there are a set of, more restrictively licensed images. So lots of people want the share-alike. Let me just clarify one thing about this share-alike. Some photographers don't understand when that kicks in. Merely using the photograph in a document is not creating a derivative work, and therefore does not require the whole document to be licensed under this term. And in fact, we had a court case involving this. A maker of an atlas in Montgomery County, actually, it involved the Montgomery County atlas. Someone had taken a photograph up on the C&O Canal of one of the locks, and the atlas maker used that image on the cover of the atlas, and it was licensed under this attribution share-alike license. And one of the claims made by the photographer was that using the image on the cover meant you had to license the entire document under this same license. And the court said, no, that's only true if you manipulate the image in such a way that you've created a derivative work of the image. Merely co-locating an image with other content does not create a derivative work and doesn't require the use of this license. So the only thing you have to do, if that's the license that you're relying on, is give credit in a situation like that. So, if you were to go from this database, the 2 sets of images that are the most easy to use are the ones up top at the attribution license, because they're you clearly only need to give credit. And if all you're doing is popping a document into a blog or into a document, you can still use these images, the attribution share-alike license, because merely popping an image in. Hello? Did I lose you?
Here we go. I think you're back on now.
Huh. How much of that did you miss?
Probably about 20 seconds, I'd say.
Oh, okay.
I thought it was me.
Huh. I didn't do anything different on my end.
How bizarre. Okay.
Anyway, let me stop here and just talk about, we can talk through more questions around the CC licensed material if people have some.
It doesn't look like anything is coming in yet.
Okay. Is this, I mean, I'm curious to know whether people already knew about this and whether using CC licensed photos from Flickr is already part of your practice, or is this news to folks?
And are you able to see the responses that are coming in now?
I'm starting to, and Kenneth had a question that I didn't get to.
It looks like it's kind of 50-50 news to me, or,
Yeah.
I've already kind of knew about this.
Right. Okay. Well, anyway, this, I don't want people to feel like they can't rely on fair use, because I would imagine in a lot of the uses you're making, you have a reasonable chance, it's reasonable to think you're making a fair use. But for folks who feel like there might be on the line and want additional certainty, this, there's a lot of good images in this database, and this would be another source of images that folks can use. And then for those of you who are taking your own photographs, we could talk for a minute about who owns that photograph. If you are taking the photograph as part of your work for your employer, so that you are basically creating a copyrighted work and you're doing it within the scope of your employment, then the bad news is you don't own the copyright. Your employer does, because that's treated as a work made for hire. And then your employer could choose to license those photographs under a Creative Commons license if they wanted to share them more broadly. So to the extent that the land use planning community is doing a lot of image creation and a lot of image sharing, I would just say, consider whether tagging those images with a Creative Commons license to let the world know the terms under which you're willing to share those images is something to consider. And you can be pretty specific about what it means to give attribution. So to use the licensed material, you have to give credit as the person sharing it directs. And so they might say, this was taken, copyright by the XYZ Planning Commission, photographer was Ann Smith. And, if that's how you want the work to be cited, you can say, you can do anything you want with this as long as you give attribution properly, and this is what giving attribution properly means to me. So that could be appealing if, to the extent that the commission themselves is the owner, or if the commission itself is the owner of the copyright, but they want to share it and get credit for it. The CC license might actually be a tool to accomplish that goal. Okay, so we are seeing a mix of different ideas. I thought, let me, so here's a use case. I'm not going to give legal advice about this, but if you were going to make a downtown plan for a community like Bethesda, here we have a couple of images that were taken. If you just went on the web and said, well, I need, a photo that has these attributes because that's sort of the look and feel I want my report to have. That's not the greatest transformative use argument because it's not clear that you need this photograph for your purpose. And certainly if that image were taken out of a stock photography site, for example, the photographer might well say that this is exactly the kind of use that I'm marketing my work for exactly this kind of use. So I'm not going to give legal advice on it, but where it's just, I like the color and the composition of this photograph, but there's nothing clearly tying my need for this image to the message I'm trying to communicate with this plan. That tends to be a weaker fair use case than if the image is of some building like the central image about the Bethesda Theater. There's a better argument for the need to use an image like that because it is part of the place that this report is about. And it's distinctly so the user immediately knows, or the reader immediately knows why that image is there and what it's communicating. So that would be just looking at these three different images. The middle image is the one that has the best case for making a transformative use because it's there to help communicate that this is Bethesda and this is a plan about Bethesda and here's a part of Bethesda that's recognizable to anyone who knows the area. But it's also not that hard to get a camera, walk down the street and take an image like that, or to go on Flickr and find a Creative Commons licensed image that has some of those qualities. And to the extent that, I think this is sort of useful information about how copyright in images works. In the practicalities of it, it's not like we're having this session because a lot of people are being subject to lawsuits as far as I understand. So that's just a data point about photographers, that many photographers do feel that the internet has really treated them unfairly, that their images are used all over the place without any credit and without any compensation. I will warn you that there are some lawyers who have started to develop practices representing photographers because copyright does have a provision that requires an infringing party to pay attorney's fees if they don't have any good sort of bona fide defense for why they're using it. I don't think from a practical standpoint that the use in a land use plan is as attractive a lawsuit as others, but there are some lawyers that are willing to sort of send threatening letters to lots and lots and lots of people and see what they can get in terms of settlements. I had one student whose family owns a restaurant, and they used some images they got off Flickr, not Creative Commons, just general Flickr, in their menu. And somebody spotted it and actually sent them a threatening letter and wanted a couple $1,000s to settle it, and the family paid to just get out of that. So lawyers are realizing that they can make a living by getting a few $1,000s here and a few $1,000s there from people that they threaten. So you may or may not have gotten such a letter. Again, I would say land use planning looks to me like a pretty unattractive place for a lawyer to go make that kind of threat, but it is out there, and so it's worth at least coming up with some internal guidelines about when you feel comfortable that this is a fair use, or when you think using a Creative Commons licensed photograph might be the better practice, or taking your own, if you know, which is obviously the best way to do it if that's easy and feasible. Are there other? Let me just try to see what else is
Yeah, I
coming
think
in.
there's a really good question that has definitely come up
Okay.
before. Does the presence of an identifiable person affect any aspect of how a photo can be used? So, for example, a planner is at a public event and takes a photo, and there's a mixture of, you know, adults and children, and they want to post it to their website or put it into a plan. Do they have to get any kind of consent from those people that are identifiable?
Yeah, that is a good question, and my answer sadly is not going to be as clear cut as you want it to be, because that's not a copyright law question, because the copyright belongs to the photographer, but individuals have a right that's called a right of publicity, and that right is created by state law. Everything that we've been talking about so far is federal copyright law. It applies equally across the United States. Unfortunately, my answer to you is it depends, and it depends on what state you're in and what the state right of publicity law is. So about half the states have some kind of right of publicity protection. So in half the states, the answer is yes, you can clearly do that without a problem. In the other half, we have to look. Most of those state laws only give the right of publicity against a commercial use of someone's image or likeness. So, and most of them have some kind of newsworthy exception. So certainly when journalists take a picture and somebody is incidentally in the photograph, that's permitted even in a place that has a right of publicity statute. So, in a land use plan, probably a pretty good argument that it's not a commercial use, that it falls on the newsworthy side, if anything. Best practice is to try to get the release when you can, but from a legal perspective, you'd have to do a little bit of due diligence, but in many states, that use would probably be permitted. What else do we have?
Okay, so I need a photo of the New York City skyline for a report that I'm writing. If I use Google to search for an image of a city skyline at sunset, the image that I find from Google, is it considered transformative and therefore fair use?
Yeah, so again, I'm not going to give you legal advice, but by itself, you need to have a more complete explanation of why you need the New York City skyline in order to help the case. So again, transformative use is not an on-off switch. It's about sort of the context, and not all courts would agree in all cases. So it's a spectrum. The strongest transformative use is I need this particular image to make this particular point. As you move away from that to here's a general idea that I want to communicate, and there are multiple different images on the internet that might help me do that, and this is the one I picked, that could still be considered a transformative use, but the case is weaker because the connection between your use of that copyrighted work to make that point is not as close. And that's where you might well get a photographer that says, why'd you pick on me? You could have picked on someone else. And so that's the risk that you run in a situation like that.
Okay. Has the Creative Commons license system been effective in general? Have there been any issues?
As far as we know, yes. I mean, there are more than 1 billion objects on the internet that have that license, so one of those licenses associated with it. So in terms of people, the original idea was, would people be willing to share, and would they be willing to share under these different options? So I think the data shows yes, with more than 1 billion objects. And in terms of on the user side, there are lots of people who do rely on using Creative Commons licenses, either because they like the general ethos and the idea of sharing with credit, or because they just feel more comfortable that they know they have a license, and it's more clear to them what their rights are. The licenses have been tested only in a few cases, so there's been remarkably little litigation around people complaining that the use is in violation of the terms of the license. We've had a couple of cases in the U.S., we've had a couple of cases in a couple of other countries, but by and large, we don't see a lot of litigation. The other interesting phenomenon is people often ask, well, does Creative Commons help copyright owners enforce their rights? And our answer is no. You're in the same position that you would be in if you put something up on the internet under full copyright. You still have to, people can still copy paste, and then it's up to you to decide what to do about that. But because Creative Commons has essentially created a set of standardized understandings about what is okay and what's not, there's been a little bit of community enforcement where somebody who knows about Creative Commons sees a use of, let's say, a non-commercially licensed object on a clearly commercial website, and they might call it out and say, wait a minute, you didn't have permission to do that. So in that way, the copyright owner gets kind of a little help from their friends, if you will, other people who are part of the CC environment or ecosystem and want to respect the boundaries that the copyright owner put by the particular license that they chose. Other questions?
Yeah, and if you want to scroll down any that you see that you might want to answer. Okay. For the streetscape photo in the Bethesda example, would fair use typically cover use that image in another city plan as an example of streetscape that the other community would want to replicate?
Wait, I want to make sure I understand. Oh, yeah, I think that would be a good transformative use argument, is that I'm using this particular photo because it represents this particular streetscape, and it's this particular streetscape design that I am suggesting in my proposal that we try to do in this new plan. And I need to be able to show you what I'm talking about with an image that depicts the design. And if this particular photo is an effective way to make that point, then the purpose of using the copyrighted work is not to compete with the copyright owner, but to make your point about an attractive streetscape design. So that would be the type of use where you'd have a pretty good fair use argument.
Thank you. What are the mechanics of obtaining a Creative Commons license?
Okay, all right, so you can basically, if you go to, there are lots of ways to do it. So one thing to be clear is from a formal perspective, What a Creative Commons license is what we call a non-exclusive license. You're not giving up any of your rights. What you're doing is giving permission. And copyright law is very generous about the way you give permission. So there's not a, you can simply say, hey, this work is licensed under a Creative Commons Attribution 4.0 license. And that you've just given a Creative Commons license because that's good enough. But if you go to the Creative Commons website, you can basically walk through this little license chooser where you basically look at the different conditions that you want. Are you willing to permit adaptations to be shared or not? And do you want the share alike condition on that, or are you simply willing to let people reuse your work creatively? Are you willing to permit commercial uses or not? If you're willing to say, yes, you can do anything you want with this as long as I get credit, and I'm willing to permit commercial use, then you get this license. And if you want, you can copy paste this HTML right here onto your website, and you'll end up getting this logo icon that will link to the license text like that. So, you certainly don't have to get the license in the HTML format. Alternatively, you could just copy this link right here and say, this image is licensed under this license. And that's the sort of shorthand way of doing it. But if you like having the icon on your web page and you want sort of this, then you can go through this license chooser on the Creative Commons website in order to choose. And if you were to say, I don't want to permit commercial use, then you get a different license. And similarly, if you don't want to permit derivative works, you get a different license. Someone asked the question about searching for CC licensed content. So there is, on the Creative Commons website, we've tried to basically aggregate what search engines that try to look only for CC licensed content. So here are a range of basically sources that are willing to set that. What Google did is they didn't explicitly say that you're searching for CC license, but in the advanced search under Google, you can filter by license type. I have to tell you though, those search results are very noisy because all they're searching for is the presence of a link to a Creative Commons license on the web page. It's not a nice clean result where you can be 100% sure that the content that you're seeing is the content that has the CC license on it. The Flickr database is better about that because those are images that are explicitly CC licensed and you're only getting CC licensed content there. But you can, for example, if we wanted to do a New York City skyline search, we would get a wider range of images. Here's one from Pixabay. And we do, but it's not clear that this is CC licensed. Or let me just, oh no, it is. It's over on the side. Okay, so this is this is CC0, so that worked. So you might just use the CC search engine as an aggregator, essentially, of all the different places to search for CC content. What else do we have, Christine? I haven't been able to read through all these other questions.
When you're given pictures or footage from an outside photographer, is it a good idea to have them sign some sort of agreement allowing access just in case later on they claim that they never gave you access?
Yeah, I think as a general principle, if you can clear something up in advance, you save yourself the trouble down the line. So there are a couple of different ways to do this. When you're, if you have hired that photographer to take the pictures, I think it's really good to deal with what happens to the copyright in those photographs in whatever employment agreement you have. If you actually want to own the copyright, you can have the photographer agree to assign that copyright to you. To make that effective, that actually has to be in writing. That is, if you want to give up copyright rights, the only way you can give them up is to do it in assigned writing. Otherwise, all you have is a non-exclusive permission and a license. And although what happens in the scenario that you just suggested is the photographer will agree that you have some kind of license because they know that you hired them to take these pictures for them. But because you didn't talk about it, the scope of that license is uncertain. And where we get disputes is often when some use is outside the scope of what the photographer thought they were giving you permission to do, and then we can have a fight about that. So I definitely think getting clarity up front is the way to go.
Okay. Is work
go ahead.
by a client that is released to the public considered fair use for use in the consultant's marketing materials, even if the client agreed in contract that the work is owned by the client?
Wait, can you repeat that? I just want to make sure I'm connecting the dots here.
Sure. Is work prepared by a client that is released to the public considered fair use for use in the consultant's marketing materials, even if the client agreed in contract that the work is owned by the client?
It can be. You know, a lot of people are asking for more legal certainty than I can offer you. But, you know, you just have to sort of go through the flow chart. Are you making a use that's covered by copyright? Yes. You're making reproductions. You're making public display. Do you have a fair use argument for why you're using that? Sure, you want to show off your work, and the purpose of using it is to communicate to the public work that you've done. You know, that's a pretty good fair use case. As long as your contract with the client doesn't rule it out. One thing we should make clear is that your copyright rights and your fair use rights are the starting point, but anything that you agree to in a contract can basically, you know, override that. In the same way that a copyright owner basically starts out with a lot of control, but they can give up that control through a contract, an assignment, or a Creative Commons license. Similarly, if you have fair use rights, you can give up those fair use rights in a contract. And so even if it would have otherwise been okay, if the client said, and you're not permitted to use my project in your marketing, then that would be prohibited. But in the absence of any contractual provision like that, it seems to me that you'd have a decent fair use argument that, you know, the purpose of using this is to illustrate my own work, not to compete with the client.
Okay. I think we'll take one more question and then we'll wrap up. And this has come up in a couple questions so far in one way or another, and that's the Freedom of Information Act. So how does Freedom of Information request affect site designs presented to planning commissions that may be covered by copyright?
Yeah, so, I mean, the Freedom of Information Act is about getting access to the work. Copyright actually doesn't govern access per se. What it governs is the making of copies and the distribution of copies and the display of copies. That being said, with modern technology, the only way to respond to a Freedom of Information Act request is to make a copy and give it to the person. So the making of that particular copy to satisfy one of these requests would very, very, very likely count as a fair use because it's part of this broader governmental scheme around access to public documents. But the person who made the request doesn't therefore get the right to publicly distribute and sort of broadcast the document to the world. They might if they have a good fair use purpose for doing that, but it's not automatic. I mean, I guess that's, some of these questions run the risk of conflating or confusing access to a copy with, access to the rights to do things with that copy. Just because you have a right to have access to a copy doesn't automatically then give you a license to broadcast the work to the world. And that's the kind of issue that would come up in the FOIA context like this.
Okay.
Does that answer the question?
I think so. So I think we'll go ahead and wrap up now, as we're just about at 2:30. Michael Carroll, thank you for joining us today and for kind of sifting through all of these questions. And for the Urban Design and Preservation Division, and Margaret Rifkin of the division, thank you for sponsoring today's webcast. And we'll wrap up now. Again, you can get a PDF of this presentation at our webcast webpage, ohioplanning.org/planningwebcast. And we'll have this up on YouTube probably by Monday, so you can share it and take a look at it. And everyone have a great weekend and a safe holiday. Thank you.
Great. Thanks to all. Enjoy your holiday.
Thank you.